Imagine a company borrowing hundreds of crores from banks, financial institutions, or debenture holders, but secretly failing to register the charge over its assets. The lenders believe their security is protected. The board assumes documentation is complete. Investors continue trusting the company. But suddenly, insolvency begins. Creditors rush to enforce security, and then comes the shock. The charge was never properly registered with the Registrar of Companies. Now lenders panic. Priority disputes begin. Directors face allegations of governance failure. Due diligence reports expose compliance gaps. And one unregistered charge creates massive litigation, creditor conflict, and financial chaos. This entire legal framework governing registration of charges is built around one of the most powerful creditor protection provisions under the Companies Act 2013, Section 77, relating to duty to register charges. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing one of the most practically important financing and secured lending provisions under corporate law. Section 77 directly affects banks, financial institutions, debenture holders, companies, insolvency professionals, directors, investors, and compliance professionals. This provision sits at the heart of secured corporate finance governance. To understand Section 77 properly, we must first understand one fundamental commercial reality. Modern businesses heavily rely on borrowing. Banks lend against assets. Financial institutions secure loans through charges. Debenture holders rely upon security interests. Creditors require legal assurance that company assets are available as enforceable security. Without a reliable charge registration system, commercial lending would become chaotic and legally uncertain. Section 77 solves this governance problem. Now let us understand the legislative philosophy behind Section 77. The law wants transparency regarding encumbrances created over company assets. Creditors, investors, and regulators must know whether company assets are already charged or mortgaged. Secretive borrowing structures create enormous risk. Charge registration therefore protects financial transparency and creditor confidence. Now let us understand the statutory framework practically. Whenever a company creates a charge on its property or assets or undertakings, whether tangible or intangible, within or outside India, the company must register particulars of the charge with the registrar within prescribed timelines. This requirement is mandatory and extremely important. Now let us discuss one hidden conceptual understanding immediately. Section 77 applies not only to physical property like land and buildings. It may also apply to movable assets, receivables, book debts, floating assets, and other forms of security interests. Students frequently underestimate the wide commercial scope of this provision. Now let us discuss what exactly a charge means practically. A charge is a form of security interest created over assets to secure repayment or performance of obligations. The company retains ownership, but the creditor receives enforceable security rights. This distinction is very important. Now let us discuss fixed charge versus floating charge concepts. A fixed charge attaches to identifiable assets like land, machinery, or specific property. A floating charge generally hovers over changing classes of assets such as stock in trade or receivables until crystallization occurs. This is one of the most important conceptual areas in corporate finance law. Now let us discuss why registration becomes critical. Without registration, third parties may remain unaware that assets are already encumbered. This creates creditor conflict and financial uncertainty. Section 77, therefore, promotes public notice and transparency. Now let us discuss the practical filing framework. The company must file prescribed particulars of the charge with ROC within the statutory timeline along with the instrument creating the charge where required. Timely filing is critically important. Now let us discuss the most important practical form connected with Section 77, Form CHG1. This form is extensively used for registration of charges other than debentures. Professionals handling corporate borrowings regularly interact with this form. For debenture-related charges, CHG 9 becomes highly relevant. Now let us discuss time limits practically. Charges must generally be registered within prescribed statutory timelines from creation. Delayed registration may require additional fees and condonation mechanisms subject to legal provisions. Time discipline becomes extremely important. Now let us discuss one hidden governance issue. Many companies assume that because loan agreements are signed and banks have internal documentation, ROC charge registration is automatically handled. This assumption creates enormous compliance risk. Responsibility must be monitored actively. Now imagine a company borrowing large amounts against factory assets but failing to register the charge properly. Later, insolvency proceedings begin. Other creditors challenge security priority. The lender faces serious enforcement complications. This demonstrates why Section 77 is commercially critical. Now let us discuss board meeting governance. Whenever companies create charges, directors must carefully review nature of security, borrowing limits, asset encumbrance implications, filing timelines, documentation completeness, existing creditor rights, financial covenants. Weak governance in this area can create catastrophic consequences later. Now let us discuss practical case study understanding. Suppose a company executes loan documents with a bank and creates security over inventory and receivables. Due to internal negligence, CHG1 filing is delayed significantly. Years later, liquidation proceedings begin and creditor priority disputes arise. This becomes a classic Section 77 compliance failure scenario. Now let us discuss another example. Suppose promoters repeatedly create overlapping charges with multiple lenders over substantially similar assets without maintaining proper transparency. Financial distress later exposes conflicting security claims. Litigation escalates immediately. This demonstrates why public charge registration matters deeply. Now let us discuss one important examination trap. Students frequently assume charge creation itself automatically ensures complete legal protection. That understanding is incomplete. Registration plays a critical role in enforceability and transparency. This distinction is fundamental. Now let us discuss another hidden concept. Section 77 applies to charges created within or outside India. Cross-border asset financing structures, therefore, also require careful compliance analysis. Now let us discuss consequences of non-registration practically. Failure to register charges may affect enforceability against liquidators and creditors. This can severely weaken security rights during insolvency or liquidation. The commercial consequences can become enormous. Now let us discuss connection with insolvency law. During insolvency proceedings, registered security interests become critically important for creditor priority and enforcement rights. Resolution professionals and liquidators examine charge records carefully. Now let us discuss ROC records and public notice philosophy. Charge registration creates searchable public records, enabling lenders, investors, and stakeholders to evaluate corporate borrowing exposure transparently. This strengthens commercial confidence and due diligence reliability. Now let us discuss modification and satisfaction of charges. Charges evolve over time through restructuring, enhancement, or repayment. Corresponding filings become necessary to maintain accurate public records. This demonstrates that charge compliance is an ongoing governance process. Now let us discuss important forms further. CHG 4 becomes relevant for satisfaction of charge filings. Professionals involved in loan closure and repayment monitoring must understand this carefully. Now let us discuss common compliance mistakes. Incorrect asset descriptions, delayed filings, improper instrument attachments, mismatch between sanction letters and charge details, failure to track modification filings, ignoring satisfaction compliance, weak board documentation. These operational failures create serious risk. Now let us discuss practical due diligence perspectives. Investors, lenders, and acquirers carefully review ROC charge records before transactions because undisclosed encumbrances can significantly affect valuation, security rights, and acquisition risk. Charge due diligence is one of the most important financing review exercises. Now let us discuss judicial philosophy. Courts generally support transparency and creditor protection principles underlying charge registration frameworks. Commercial certainty remains central to secured lending systems. Now let us discuss listed company implications. Listed entities creating major charges may also trigger SEBI disclosure and governance obligations depending upon materiality and transaction structure. Market transparency becomes critically important. Now let us discuss FEMA and cross-border financing implications. Where foreign lenders, overseas security interests, or external commercial borrowing structures are involved, FEMA and RBI compliance may also intersect with charge governance. This area requires integrated legal analysis. Now let us discuss income tax and accounting implications. Borrowing structures, security creation, and asset encumbrances significantly affect financial reporting, disclosures, and accounting treatment. Now let us discuss practical governance red flags. Repeated delayed filings, multiple overlapping charges, opaque related party financing, unclear asset descriptions, unregistered modifications, missing satisfaction filings, weak lender coordination. These indicators require immediate professional scrutiny. Now let us discuss the role of professionals individually. Company secretaries coordinate ROC filings and compliance timelines. Chartered accountants evaluate borrowing structures and financial disclosures. Advocates draft security documentation and analyze enforceability. Cost accountants evaluate financial efficiency and covenant implications. Compliance professionals monitor ongoing charge governance. Every professional contributes to secured lending transparency. Now let us discuss practical drafting precautions. Always describe secured assets clearly. Always monitor filing deadlines carefully. Always reconcile loan documents with ROC filings. Always track modifications and repayments. Always verify lender approvals and resolutions accurately. Always maintain centralized charge registers internally. These precautions dramatically reduce future disputes. Now let us discuss one deeper governance insight. Section 77 teaches an extremely important principle. Transparency in borrowing is essential for healthy corporate finance systems. Hidden encumbrances destroy commercial confidence. Now let us discuss connection with investor protection. Investors evaluating companies rely heavily upon financial transparency and debt disclosures. Undisclosed or improperly registered charges can distort financial risk perception significantly. Now let us discuss the broader philosophy behind Section 77. Corporate borrowing flexibility must operate alongside transparency, creditor protection, and public disclosure. The law therefore requires companies to openly disclose security interests affecting their assets. Section 77 preserves this balance. It strengthens commercial certainty. It protects creditors. It improves financial transparency. And it reinforces trust in corporate lending systems. Now let us conclude with the larger significance of Section 77. This provision is not merely about filing forms with ROC. It governs the legal credibility of secured corporate borrowing itself. It affects lender confidence. It affects insolvency rights. It affects investor trust. It affects financial transparency. And it affects the integrity of commercial lending systems throughout the corporate ecosystem. For company secretaries, chartered accountants, advocates, CMA professionals, compliance officers, bankers, investors, and directors, understanding Section 77 is absolutely essential because defective charge registration frequently becomes one of the most dangerous governance failures in real corporate finance practice. A professionally governed company never treats charge registration as a routine filing formality. It understands that proper charge governance protects lenders, investors, stakeholders, and the credibility of the company's entire financial structure within the corporate ecosystem itself. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India (ICSI), and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.